I am your favorite Ezine Emanuela. In today's lecture, let's look at attempts to commit an offense, right? Attempt is an inchoate offense. This means that it is a preliminary offense. It does not stand alone. It must be mentioned in relations to offenses in chief, right? And that is why you cannot just sue someone for attempt. The court will be like, attempt for what? Right? So you must mention an attempt in relation to offense in chief, such as an attempt to commit murder. Right? So attempt revolves around section 4 of the criminal code. Although the provisions of the criminal code did not define what an attempt is, however, under that section 4, it gave us circumstances that could constitute an attempt to commit an offense. In the case of Jegede versus State, the court adopted the provisions of section 4 of the criminal code, stating that what is contained in section 4 are circumstances that could amount to an attempt to commit an offense. Attempt was defined in Stevens Digest of Criminal Law, 5th edition. It defined an attempt as an act done with the intention to commit a particular offense, performing series of activities that could amount to the actualization of that intention if not being interrupted. That means that had it been that you were not interrupted, you have committed that particular offense. That is an attempt according to Stevens Digest. And that was adopted in the case of Christopher Nnagbo versus COP. Yeah. The rationale behind the criminalization of attempt is that the law is not concerned about your intention. Only your intention. Your intention is immaterial to the law. What matters or what the law punishes is any slightest move in furtherance of that your intention. You might have the intention to deal with your uncle. Maybe your uncle has been blocking your way, and you had the intention in your mind that you will kill that uncle. The law is not concerned with that intention. When the law will come in is when you now make a move or you make further steps to kill that your uncle. That is what the law is concerned about. So, but then, when or how can the court determine the intention of parties? Because there is this saying that not even the devil knoweth the intention of man. The law determines the intention of parties based on your actions. Your actions will show whether or not you have the intention to actualize that, or you have the intention to commit that offense. So if someone buys poison now, like, it cannot be said with certainty that that person attempted murder. The person just bought poison. He has not made any further move, right? Just bought the poison. It cannot be said with certainty, emphasis with certainty, that the person has attempted murder. But when the person buys poison, takes it to a neighbor's house, tries to put it in the food, and someone cuts him, maybe at that time he was still raising his hand like this to put it, someone cut him, he did not actualize that, but he has attempted to commit murder at that point. So we have mental element of an attempt. The mental element of an attempt is intention. Intention matters a lot, and like I said ab initio, your action determines your intention, right? So it follows to say that any offense that intention is not its ingredient, any offense that does not require intention to be an offense, cannot be said to have been attempted. just like manslaughter. In manslaughter, there is no intention, right? So it cannot be said to, like, someone cannot be said to have attempted manslaughter, because manslaughter is devoid of your intention. So in the case of R versus Seyudu, the court held the party not liable or not guilty of rape because there was no proof of penetration. And also in R versus Effiong, the court held the party not liable for rape due to the fact that there was no proof of application of force. Then we have conditional intention. Conditional intention is the intention that is based on a certain condition. Maybe now I have the intention to steal from my friend's bag, or maybe I saw one fancy bag and I thought, something must be inside this bag. I had the intention to steal from that bag only if I found something that is worth stealing in that bag. I have intention to steal from the bag, but only if I found something worth stealing in the bag. That means if I open the bag and I didn't see anything reasonable, I will not steal from the bag. That is conditional intention. And in the case of R versus Hazien, the court stated that once a person has intention to steal, if only he finds something that is worth stealing in the bag, then the person did not have a present intention. This caused controversies in the legal profession, and the English Court of Appeal had to state the case to the House of Lords. And then the House of Lords resolved that when a person had an intention to steal only if he found something worth stealing in the bag, that the best thing to do is to sue the person, to charge the person for stealing some or all of the items in the bag. Don't charge the person for stealing specific item, because it might end up that that specific item is not in that bag, right? Just charge him for stealing some or all the things in the bag. See you in the next class. Please subscribe to my channel. Show me love. Thank you.